This week in Political Science 485, we talk about the Marbury versus Madison case. A little background: Thomas Jefferson defeated John Adams in the 1800 presidential election. Before Jefferson took office, March 4th of 1801, Adams and Congress passed the Judiciary Act of 1801, which created the new courts. It added judges and gave the president more control over the appointed judges. The act was essentially an attempt by Adams and his party to frustrate his successor, as he used the act to appoint 16 new circuit judges and 42 new justices apiece. The appointees were approved by the Senate, but they have not been valid until their commissions were delivered by the Secretary of the State. So William Marbury had been appointed the Justice of the Peace in the District of Columbia, but his commission had not been delivered. Marbury did petition the Supreme Court to compel the new Secretary of State, James Madison, to deliver the documents. Marbury, joined by three other similarly situated appointees, petitioned for writ of mandamus compelling the delivery of the commissions. So the court found that Madison's refusal to deliver the commission was illegal, but did not order Madison to hand over any of Marbury's commissions via writ of mandamus. Instead, the court held that the provision, Judiciary Act of 1789, enabling Marbury to bring his claim to the Supreme Court was itself unconstitutional, since it purported to extend the court's original justification beyond which Article 2, Section 2 established. So before the case, they're basically added a total of 42 new justices apiece and the 16 new circuit justices, and the appointees were approved, but the Senate was not make it official until their commissions have been received. So how this impacts today is the Supreme Court declared that it had the power of the judiciary review, such as today you can still see. The Constitution says that it is the supreme law of the land and that no law may be passed that violates the Constitution.